Hi, everybody. Thank you so much for joining us today. We have a fantastic webinar. I was just saying it's not very often that you get a chance to just listen to an attorney explain things to you for free for an hour. So take advantage of this. You don't need to take notes because you will receive a copy of the slides later on today. You're also going to receive a link to this webinar on our YouTube channel. We record all of our webinars. We put them on our YouTube channel so that you can go back and watch again, or if you missed the live show, you can come back later for an encore. But we've got this fantastic attorney, Carly Mader from Tyler Mader, and she's going to be talking to us about guardianship and alternatives to guardianship and transitioning into adulthood for our loved ones. Real quick, a little bit about Consolidated Planning Group and who I am. Consolidated Planning Group is a financial planning firm primarily, but we focus on serving families where there is a special needs loved one or individual in your family. It doesn't matter if it's intellectual or developmental, whether they're impacted heavily by their diagnoses or just a light impact in their life. Whatever you have going on, we want to be here to help you think about planning for the future for your loved one and for yourselves. We've been in business for over 30 years doing, financial services, but now we have really turned our niche towards focusing on families because Allison Schaberg, the owner of our company, has uh, two loved ones in her life with disabilities. And when she was going through it with her own kids, she saw how difficult this process is and how nuanced and how specialized the information is that you really need to understand. So we have dedicated ourselves to learning and living this life. We are members of the Special Needs Planning Community, Special Needs Planning Academy. Sorry about that. We are Social Security Advisors, National Certified Social Security Advisors, and I'm a chartered special needs consultant through the American College of Financial Services. Almost all of the clients that we serve have a loved one with some kind of disability in their lives. So families come to us for things like protection plans, lifetime care planning, thinking about the cost of care for your loved one's future and how you're going to set that aside and have that be there to take care of them for the rest of their life, not just your life. Transition planning is big. We can help with ABLE accounts and understanding the different buckets of money where you can keep money for your loved ones without jeopardizing their benefits. And then, of course, we're here to educate you and to advocate for you. Out of the entire United States, there are over 263,000 financial advisors, but they're not all created equally, just like attorneys. Not every attorney can help you with special needs planning. Not every financial advisor can help you with special needs planning. So you're in the right place when you're here with Consolidated Planning Group, because out of those 263,000 financial advisors I mentioned, fewer than 200 of them focus on special needs planning, which is less than 0.1%. So a few bits of advice on planning for your future before I turn everything over to Carly. We know it keeps you awake at night to think about who is going to care for your child when you cannot do it anymore. We want you to develop that future care plan now. It's going to help you be a better parent because you're going to be able to sleep better at night, and you're going to have a longer runway to make small incremental changes rather than, leaving it to the end and then you have to do a lot of really big changes all at once, possibly. Think about what's going to happen after high school. There are lots of fantastic options, vocational, residential, and educational options. And just make very careful consideration before you decide that a sibling is going to be willing or able to step in and take care of their sibling, because, it can create some tension on both sides of that relationship. And that's not really what you want for your children. One last thing I want to say before I turn everything over to Carly is that we're in webinar mode, which means that we cannot see you or hear you. So please, any questions or comments that you have, we would love to get to those, but you're going to have to put them in the chat box. Okay, so use the chat box for your questions and comments. And Carly, let's talk about guardianship. Thank you so much for being here today.
Yes, thank you, Michelle, and thank you for you and Allison's work. I mean, what you all do is just very essential to the disabled community. Hi, everyone. I'm Carly Mader, and I'm the partner in the firm, Tyler and Mader. My partner is Gidget Tyler, and we have one other attorney in our firm. Her husband, Chris Tyler, just joined us, and we help with Social Security benefits. We help with guardianship, special needs planning, special needs trust, estate planning, and things like that. So we do like to say that we're a full service disability law firm. We've even taken on Medicaid a few times. So we truly love helping the disabled community. And much like Allison's story, I also have a daughter with mental and physical disabilities. You'll see a picture of her on my slideshow. So just so you know, I come from a place of understanding how hard it is day by day. And I don't take these topics lightly and these decisions lightly. I understand that these are hard for parents to go through, especially this topic, transitioning into adulthood. So what I'm going to touch on today is guardianship. Does my child need it? Are there alternatives to guardianship? Yes, and we'll go through those. And then just the guardianship process in general. It is a pretty lengthy legal process, and a lot of people don't understand that there are several steps that the court needs to see and kind of validate along the way. So we'll go over that as well. Okay, so what happens when my disabled child turns 18? I think that it's a little scary because sometimes you hear information out there that you're not sure is correct. But from a legal standpoint, when your disabled child turns 18, they are considered an adult in Texas. That means they are legally able to make all of their own decisions, whether it be medical or financial. Can you help them along the way? Of course. But when it comes down to consenting or signing a contract, they are allowed to do that at 18. So that is a little scary for some parents if your child does have an intellectual disability, because in their mind, right, they're not truly 18, they're not truly an adult. Of course, some neurotypical 18-year-olds should not be making very difficult decisions and signing contracts and all of that, but legally they are able to. So how can we, protect a child with disabilities, especially intellectual disabilities, from not being treated as an adult under the law, so you can protect them further, much like you are doing now if they are minors. Okay, so a very important distinction is contractual capacity versus incapacity. This is important when we're talking about the guardianship process and the alternatives to guardianship. Contractual capacity is actually kind of a lower standard to meet, right? Contractual capacity is, once a child turns 18 and they're considered an adult, if that person, that newly adult, understands the contract, the agreement, and we'll go over what those are. If you've heard of power of attorney documents, we'll go through those. If they can understand that agreement and understand that they are giving rights to certain people to start acting on their behalf, then they can sign. They have the contractual capacity to sign that agreement. As opposed to like that next bullet point says minors. So in Texas, if a minor signs a contract, because you might say, well, my child signed something for like a sporting event or something like that. Yes, but legally that can be voided. because under the law, they don't have the contractual capacity yet because they're minors. But at 18, if you have a disabled adult, they are allowed to sign, and it's a legally valid contract once they sign. If your child can understand the basics of a power of attorney agreement, a supportive decision-making agreement, and we'll go through exactly what those are, then they have the contractual capacity and they can sign those agreements. And that would probably be the route you want to go. It's a less restrictive means to guardianship. Incapacity. Incapacitation is an adult that, because of a physical or mental condition, is substantially unable to provide for themselves. They are unable to care for their property, and they're unable to care for themselves, meaning they need a lot of support for daily like activities of daily living, like dressing. Even if they can dress, are they properly, showering every day, or are they constantly having to be reminded? Same with, bank accounts. Are they able to handle money? Are they able to handle bank accounts? Do they understand, some of those financial transactions? So the determination of incapacitation in Texas is largely, and this is through the guardianship process, which we'll get into, is largely made by a physician. Someone with a medical degree needs to make that determination of incapacitation. A lawyer does not. On the other side, the contractual capacity, a lawyer can actually have a say when you're talking about signing those agreements. So those agreements do have to be notarized. So the notary public needs to know that there's no fraud happening, there's no duress, all of that, right? That's our duty. But a lawyer could say, yes, I am talking to this 18-year-old, and I do believe that they have the contractual capacity to sign this agreement. So that's a big difference between the two. Helpful questions to ask. I get this all of the time during the guardianship process is, well, how do I know? How do I know if, my, disabled adult or my child really understands? These are some helpful questions. Like I mentioned, if someone else besides the parent explained a document or explained a contract to your child, would they understand? And again, there are some adults with no intellectual disability that have trouble understanding certain contracts and agreements. But will they understand the basics? Do they understand I am granting someone else the right to act on my behalf? If they can understand kind of the basics, then you're likely looking at alternatives to guardianship. If someone explained what a power of attorney document is, or a supportive decision-making document, would they be able to again, grant those wishes to someone without feeling like, someone's talking on their behalf? It's supposed to be more about helping that individual make a right decision, not making the decision for them. They can understand that. You're looking at alternatives to guardianship. Money is a big thing, right? You don't want your child, once they're 18 and not under a guardianship, to be manipulated into maybe giving away too much money. So do they understand, basic exchange of cash and how much they would receive back? And that's something you could also, work with your child to get there. Can my child safely live alone? That's a big one, right? If they have seizures or any other physical disabilities, are they able to live alone safely? Are they able to understand that, the stove should not be on, the gas stove should not be on? Can they turn it off? Things like that. Driving is a big one in the courts. Can my child ever learn to drive? And do I want to take away that right or not? So that's a question that I get a lot. Same with voting, the voting capacity. Now, and I will explain this when I explain the guardianship process. There is, full guardianship and, full incapacitation, but there's also partial guardianship. So I have been successful for many of my clients to have them retain the right to vote in like a presidential election, because they are able to do that But, for some kids, they don't understand how to safely live alone. So there is a way to do partial guardianship. So don't think that you have to take away all rights forever. And I'll touch on that in a little bit as well. I would say the majority of concern for a lot of my clients is the medical consent. And we'll go through that with the medical power of attorney document as well. But a big thing to ask is, would my child, if a doctor asked to draw their blood or needed consent to draw their blood or to do some dental work or to have a surgery, would my child refuse that treatment? Regardless of what mom and dad are saying that they need, would your child be able to refuse that medical treatment? If it's yes, and they would be able to do that, then you might be looking at guardianship, and I'll explain that in a little bit. Also, does my child understand the legality of marriage? Marriage is also a big one. Decisions about marriage. Again, if you can sign a power of attorney, you can sign a certificate of marriage, right? The biggest problem I see with that, and we've had this happen to a client, is they were not under guardianship, that the adult with disabilities was on public benefits. She got married, she lost her public benefits. It was a really sad case. But that's another thing to ask about your child, and helpful questions about guardianship versus alternatives to guardianship. Alternatives to guardianship. So we will touch on all of these. I would start, if you'll switch to the next slide. Sorry, I'm looking. There we go. Durable power of attorney. So that's the first one we're going to talk about. Durable power of attorney is financial decisions. Helping your child with disabilities, who's now 18, if they're able to sign a durable power of attorney, they can grant you the right to help you with a whole list of financial transactions, whether it's real estate, whether it's some business, transactions. Bank accounts are the big one, right? You can sign on their behalf, and you can act for them when it comes to banking. The downside is durable power of attorney does not work for SSI applications. You cannot sign on behalf of your child for those. Social Security does require that 18-year-old to sign whatever they can. They can even, stamp whatever they can to sign that application. They need to do that. And we'll talk about public benefits at the end. But a durable power of attorney, your adult child is actually saying, I want my parents to help me make these decisions and act on my behalf now, not once I'm incapacitated. You would not want a springing durable power of attorney. That means it's only effective when that person, the principal who's signing the document, when that person becomes incapacitated or disabled. You would want your child to sign that document now, saying mom and dad can help me with all of these things right now. It's also helpful to have a durable power of attorney to talk about things with Social Security, so you can actually, act on their behalf for certain things. It's just the initial application process that you're not. But it can do a lot. A durable power of attorney is really beneficial, and you absolutely would want your child to sign one of those, again, if they have the contractual capacity to do that. So the next, I touched on this a little bit. Let me make sure I said all of them. The drawbacks of the durable power of attorney, like I mentioned, Social Security does not recognize the power of attorney when you're filling out those forms. If you do have guardianship, they will request, or they will give you some additional forms to fill out. Another drawback is the financial institutions will not allow an agent to withdraw funds or close an account with just a power of attorney. So there are some drawbacks. People ask me that a lot. Well, I have a durable power of attorney. Can't I do everything for them? No, there are some financial institutions that either don't accept them or don't accept them for certain things. They want the actual principal there saying, yes, you can withdraw this amount of funds, or again, to close an account. Some banks also require their own power of attorney. So that can sometimes be a headache, because then you have to get your child to sign another document in front of a notary public. Power of attorney only allows your agent to do the things you want to be done for you. You can still act on your own behalf, and it is revocable. So this is another thing that I like to stress when I'm talking to my clients in an initial guardianship consultation is a durable power of attorney. Yes. And a supportive decision-making agreement, which we'll get into. Those can help you assist your child with so many things, but they are revocable. If you have a child who, again, some people don't like this term, but I'm going to use it, high functioning, autism, or, a child that has some physical disabilities, but their intellectual capacity is pretty strong, but they may have some, severe ADHD or anxiety and things like that with their disabilities. Just know that if they're having some type of, even mental breakdown or whatever you call it, they can revoke all of these documents. They do not have to allow you to do any of this under a power of attorney. They have the power to revoke it. So that is probably the biggest drawback of these agreements. Medical power of attorney. I get this asked a lot too. Well, I have a medical power of attorney. So I can talk to the doctor about everything, and I can get all of the medical records. You need a medical power of attorney and a HIPAA. Your child would need to sign both of those documents, allowing you to act on their behalf. But a medical power of attorney does not automatically grant you the right to make all medical decisions. That is something that parents don't realize. Some of my clients, it only comes into play, a medical power of attorney, when that child, when your adult child becomes incapacitated. So if you're trying to prove that they're incapacitated, but they've already signed a medical power of attorney, that's hard, right? That's a hard line to walk. And some doctors, not all doctors, some doctors won't accept that. They'll say, I understand that you're the medical power of attorney and you want to consent, to this surgery or this medicine or this blood draw, but your child is standing here telling me no, and that means they have the capacity to say no. So that medical power of attorney will not trump what your child is telling the doctor, and the doctor does not want to be liable, right? And so it gets there's a gray area there, and sometimes they get concerned with moving forward with those medical decisions. So I would say there are so many times where I have had clients, their children have signed power of attorney documents. I just had a case recently. Their child signed power of attorney documents and HIPAA, and they were in supportive decision-making agreement. They were allowed to help them with a lot of decisions, but it came to a point where those documents weren't working anymore. It didn't protect that child enough. There were instances where even though they had all those documents, it was not preventing people manipulating her, and other things, that truly she was not protected enough. So they went the guardianship route. So just know that if you do start with these documents, you can always go back to guardianship if these are not working, right? So just keep that in mind. This is a good one, the Declaration for Mental Health Treatment. Again, if you have a child that has some mental disabilities and even psychotic episodes and things like that, this is really something you should look into. Disability Rights of Texas, I believe, has it on their site. You can find these forms online. If you want to make sure you have the right forms, definitely talk to an attorney, but just know they are out there. Alternatives to guardianship is the less expensive route to go. So if your child does have the contractual capacity and can understand these documents, start there. I say that, start there. But again, if they're not working, or if you're concerned that you may come into a situation, even when they're 18 or 19, where they could refuse medical treatment or something similar, then I would go ahead and do the guardianship process immediately. Declaration of Mental Health Treatment. I love this because if your child agrees to sign one of these because they know that they have these kind of mental breakdowns or psychotic episodes, then you have the power to treat them when they're having those episodes. And I think that's really important. We've had clients use these and it's been successful. I've sent these documents to clients just for free saying, no, get one of these in place because of some, kind of horror stories that we've heard. So there are some drawbacks. Even with a medical power of attorney agent, they cannot consent to the voluntary inpatient mental health services or electroshock treatment or psychosurgery. So there are some limitations, but at least if this declaration has been signed, you can treat them with medication and get some emergency mental health treatment, especially if they become suicidal and things like that. The HIPAA, I think I touched on this with the medical power of attorney. This is very important for everyone, I would say. At very least, try to get one of these in place because, even Texas Children's, if anyone's in that system, which I know a lot of you are, you have no access to their MyChart once they turn 18. And I've heard, some horror stories there too, where parents are like, oh my gosh, all of their medical records are now, I can't access them. They just went away. So really get this into place immediately right when they turn 18. All of these documents really should be in place on their 18th birthday, get them signed. But this is your child giving you consent, permission to access their medical records, to continue to be in the room, right? And discuss medical decisions with them and help them make important healthcare decisions on their behalf.
Yeah, and alternatively, go in there when they're 17 and a half and download all those records or ask for a copy of the records when they're getting close to 18.
Yes, thank you, Michelle. That's a very good point. Start downloading those documents. Absolutely. The notes, the doctor notes, which sometimes are like the most important, those after visit summaries, start downloading them. That's such a good point.
Mm-hmm.
Supportive decision-making agreement. So in Texas, we have what's called supportive decision-making agreement, which again, you can create one of these on your own. Disability Rights of Texas, I love their form. I use it. I help clients, go through it with them and their child. I like to say that this agreement covers whatever the medical power of attorney, HIPAA, the mental health treatment, and the durable power of attorney won't cover or can't cover or doesn't cover, right? Supportive decision-making agreement is exactly what the title is. It is you as the parents or guardian or like guardian was the wrong word, friend, whoever that your child wants to enter into this agreement with, they're saying, please help me make these decisions, support me in these efforts. So for example, with, work related things, I get that question a lot. Well, my child wants to go to work and they want to, go on to college, but the institution or the employer won't speak to me. Show them this supportive decision-making agreement. Just like the durable power of attorney, drawbacks, medical power of attorney, HIPAA, I saw a question come out. We can provide all of these documents. We can have your child sign all of these documents. They are valid and effective under Texas law. Will the certain financial institution accept it? Will the certain educational institution accept it? Will that doctor accept it? Those are some hoops you have to jump through. When it's all said and done, could you go to court and get a judge to make them accept it? Probably, but that takes a lot of time and effort and money and all those things. So just know that's probably one of the biggest drawbacks about these agreements is what happens when they stop working, or what if this employer won't even, abide by it? What do I do now, right? So just know they're only as good as kind of the paper that's on them and the people that will accept them. I say that a lot. I am happy with I'm happy to talk with anyone that won't accept them on behalf of my clients. Definitely want to advocate for them. But just know that is one of the drawbacks of these. But just to support, oh, go ahead, Michelle, did you want to say something?
Yeah, to me, this is like a gentleman's agreement, with your child. Like, you're going to come to me for help, right? Sign this paper.
Yeah, yeah,
Right?
exactly.
Uh,
Um,
there is
but
one quick question about the HIPAA form. Do you just fill out one, or do you need to fill out a separate HIPAA form for each service provider?
that's a great question. Definitely get the statutory one that that Texas has, right? Through the statutory law. So we create that one. That one should work everywhere in Texas. Again, some health institutions or medical institutions, they or healthcare providers, they want their own form filled out. Which again is another just red tape that is frustrating. But I personally have used HIPAA with Methodist, with MD Anderson. I know that, and I just uploaded the HIPAA showing that I was on it to a person's My Chart, and they accepted it. So, and then they were able to send me everything. Another workaround is get your access to My Chart is good. Online access, people consenting on your behalf and things like that is also a good way to get in and be able to visualize everything. But supportive decision making, it goes through my supporters can help me with all of these life decisions, finding a job, talking to schools. Schools is probably the biggest one, managing money, helping, choosing other support services, and that's kind of a laundry list, but it goes through that. There's also on Disability Rights Texas, they have the releases. So release of confidential information. Employers have, HR records and things like that they're not allowed to share. Well, your child can sign saying, I consent, I agree, I waive that confidentiality if it's my supporters, if it's my parents. Okay, so now we will get into the guardianship and the guardianship process. So if alternatives to guardianship won't work, this is, excuse me, what is guardianship? This is kind of the route that you would need to be taking. So guardianship of the person is when a court gives a responsible person, the guardian, full or partial decision-making power or authority for an incapacitated adult, which is called a ward or proposed ward before you actually get the guardianship granted, so that the guardian can protect and look after him. The court must say that the adult is incapacitated. It is a legal term to say that the ward is not able to manage certain areas of their life, and that a guardianship is required. I would say this is not a term to take to heart. I know as a parent that, Kennedy, my daughter's only 8 years old, but for 8 years, I've told people everything she can do, right? But when you're going through the guardianship process, you kind of have to change your mindset, and you're really trying to prove this is what my child can't do. They are incapacitated because they cannot care for themselves safely. They cannot live alone. They cannot manage their own property. They still need me as a parent, much like a minor child needs a parent still. This
Are
is,
you for
oh
this?
yeah, go back real quick. I wanted to make sure I had the last. The courts do take guardianship very seriously. I have to prove that other alternatives were not sufficient, did not work. So when you're trying to get guardianship right at 18, the court is going to challenge you on that. The court meaning the judge, the attorney ad litem that's appointed, and I'll talk about that. You do need to discuss and make sure that you can prove that those other support options did not work or would not work. And the biggest thing that I like to stress is it would not give that child the protection he or she needs. I like to say guardianship is just about, it's like enhanced protection. So that's why I say don't take the term to heart too much. I know it's sad when you say, well, all rights are stripped, they have no rights. Yes and no, right? Yes, you are saying that, or sorry, yes, you are terminating rights of that adult. but it's for a good reason, right? You're the parent, you know your child, you know they need that extra protection.
Ready?
Yes. Real life example. So I just mentioned Kennedy is my daughter. She's a little older now, but I love that picture.
It's so
Um,
cute.
Thank you. She was diagnosed with a rare chromosome duplication at birth. She has a duplication on her 15q chromosome. It has caused seizures, developmental delay, IDD, low muscle tone, and autism from birth, basically. She started having seizures at 5 months old. She is nonverbal. Based on kind of all of our research and knowing a pretty wide community now. There's about 7,000, maybe 10,000, probably closer to 10,000 now with genetic testing, with people with this duplication. So with more research and studies coming out in genetic testing, we're able to see more adults with Dup15q. So, you know, that kind of alerted my husband and I to understand, okay, there is, I think, only a handful, right, of adults with Dup15q that you know, do not have guardianship. The majority of them do need guardianship. So even though she's 8 years old, we know that that's probably the path we're going to take. She is nonverbal, so it would be really hard to communicate with anyone her needs and wants. And she does have seizures. She's very prone to seizures, and living alone would not be possible. So we kind of look ahead. If you have any, you know, community like that, you know, based on your diagnosis or your child's diagnosis, I would start doing that research. What other adults with this certain, you know, disability or diagnosis have, you know, alternatives to guardianship or guardianship? That's another helpful thing. And then I like to say it's enhanced protection needed. It's not, you know, stripping away all rights. I don't really like to use that term very often.
Yeah, we want to focus on the positives.
Yes, yes. Okay, so guardianship is a legal process, meaning it has to go through a court. Like I said, Texas courts take it very seriously. There are several counties in Texas. As we all know, Texas is huge. Depending on the county you live in is where you start the guardianship process. Attorneys in Texas, if they're licensed in Texas, they can file an application in any county. Majority of the counties will do hearings via Zoom, which is great. So you can have an attorney help you if your county allows Zoom. You don't have to be in person. The very first step I like to mention to my clients when I'm doing an initial consultation is you have to get a PCME. I say you have to, courts have accepted other documentation, but it's a great first step to start. It's a physician certificate of medical examination. It does need an MD. So your PCP would be a great option. A psychiatrist with an MD is a great option. It is a doctor determining the capacity of your child. That PCME is, I want to say 5 pages. I should have had it in front of me. About 5 pages. Your child does have to be in the room with the doctor, so that they're, you know, checking all the boxes. And when I'm proving up that PCME, I can say yes, that the doctor evaluated the child's capacity. I get this a lot. Can we start, you know, can we have that doctor appointment before they turn 18? Absolutely. I would start the process about 6 months before they turn 18. There is a cutoff, there is a time frame under the law that, you know, I can't file the application too early. But as long as we're within that 6 months, that's usually a good time so that we can get the hearing very close to the 18th birthday if you know for sure you're going that guardianship route. We do have to show the court that you know, we discussed and we determined that the alternatives to guardianship just wouldn't work, would not give the child the protection he or she needs. And then we file the application with that PCME. I actually attach that PCME to the application that I file in court. Majority of my clients do not need guardianship of the estate, so I have not really gone into a lot of detail about that in this presentation. Majority of my clients need guardianship of the person. It means that their estate is, less than 20 grand. They don't have a lot of money in their name. Their parents are still supporting them. And so that's typically what we file, just the permanent guardian of the person. The disabled adult is called a proposed ward until the guardianship is granted. Your child does have to be served. So that I get that question a lot. Does a cop have to come to my house and serve? Yes, they do. A constable will come and serve your child. The paperwork say that a guardianship process has been filed or guardianship application has been filed. There are other people that need to be served. Personally, it is the parents. So if both parents are not going for guardianship, then one of the parent that's not going for guardianship, so it's not filing the application, they do have to be personally served as well. They can waive that, so that's good. They can sign a waiver. Same with adult siblings. They need to be not personally served, but they need a certified service. You can waive that, which is nice. And we go through all of that with you as an attorney. I get this question a lot too. Do you need an attorney? Yes. I know it is a more expensive process. You are hiring an attorney, but there are so many steps and rules that the court requires. And it's very difficult to do it just as a layperson. There is a lot of forms that we file. There's a lot of fees associated with that. And when you are set for a hearing, it is very helpful to have someone walk you through exactly what the judge wants to hear so that you are granted the guardianship. The
Yeah,
court
there are questions in the
Yes.
chat box about why is it so expensive, and is there any kind of funding? Who can help pay for this? If we have parents who just are not financially able to pay for all this, then what happens?
Yes, I would ask ask the attorney that you talk to if they do payment plans. We have helped clients with payment plans before. Also there are like legal aid and things like that. They will do the guardianship process. It might take longer, so that is frustrating, but there are nonprofits out there that have attorneys willing to step in and do these guardianship processes for people that need this help. And I know it can get expensive. The filing fees alone are very expensive, and it can be a 6-month process. So
overall, how much are we talking here?
yeah, I think every attorney is different. We
Yeah.
charge 4,000 flat fee. We require the 2,000 to begin the initial application process, and then the 2,000. So we do try to break it up because I know that was hard for clients in the past to pay it all up front. And then we charge the other 2,000 before the hearing. So you do have a little bit of time to save for that next payment. But that covers everything except attorney ad litem fee. So my next kind of bullet point was the court does assign an attorney to your child, to your disabled adult. That attorney is representing the interests of your child. So their job is to make sure that guardianship is the route to take, to make sure that alternatives to guardianship wouldn't be better. So that kind of, I know that it makes some of my clients a little nervous that this attorney ad litem is going to ask some hard questions, or I've had cases where they're like, my son or my daughter, they present as really high functioning, but there is so much that they struggle with, and there's so much that recently we've seen they've been manipulated or taken advantage of, and these power of attorney documents are not working anymore. And so you need to present that to the attorney ad litem. The attorney ad litem does go to your house. They visit with you. They visit with your child. They'll even go talk to the child's teachers or whoever they need to make sure that this is the right way to go. The attorney ad litem also is at the court hearing. So they need their own, they do their own due diligence, and they have certain things that the judge wants to hear from them. So they'll ask a lot of questions of you as well during the hearing based on that visit. Another thing that I didn't mention was right when the application is filed, a court investigator is actually appointed first in Harris County, I know. Other counties may do it differently, but Harris County is a pretty big county. That's Houston and all the surrounding areas. They do want a court investigator appointed. That just they want to make sure that there's no fraud, that there's no one just trying to get guardianship over someone that clearly doesn't need it, right? Their visits aren't as intense. Of course, I have heard that some court investigators are, very cautious, and they want to absolutely make sure someone is incapacitated. So sometimes those visits can get a little bit more difficult than I originally tell my clients, but usually it's the attorney ad litem that does the kind of the deeper dive into the life of you and your child. Their report is usually just like, I want it set for a hearing. I want to, it's a very short report, but they have to file it in the court, and it says, let's set this for a hearing. Let's hear the witnesses, which is the applicants, you as parents or whoever is trying to get guardianship. So right now I'm an attorney that helps parents who are applying for guardianship, and then the attorney ad litem are attorneys that are representing your child. So sometimes people get confused on that, so I like to make sure you understand the difference. The attorney ad litem has its own fees. Attorney ad litem in Harris County right now, they are allowing $750. If the attorney ad litem goes higher than that for their fee, they have to prove why. They have to send in, a lot of other documentation. If they go lower, obviously it doesn't matter. But it's anywhere from $600 to $900 that I've seen be approved. That is a fee that in some courts we will collect. We will have to collect from the client separately, and we hold it in our trust account because we have to tell the court, yes, they have the ability to pay attorney ad litem. Yes, I'm their attorney and I'm holding it in my trust account. So I've had to do that in some courts. But most attorney ad litems just, file their fee petition, the court grants it, and then my clients pay that attorney ad litem directly. Then after we get all the paperwork in, there is a guardianship training. Just know that we will send you the link on that. You do have to register. You have to go through some training, make sure you're a guardian. You have to do a background check. The court absolutely does a background check on you to make sure you haven't been committed of fraud or moral turpitude, and you don't have a lot of felonies on your record. And so you do have to go through those two steps before we get a hearing set. Once the hearing is set, that is when I get together with my clients and I go over the questions that I have to prove up that your child is incapacitated and in need of guardianship. The majority of those questions during the hearing is about the PCME. So just know that I prep you for all of that before the hearing. Again, a lot of the counties are doing Zoom. Sometimes they're in person. I haven't yet had an attorney ad litem require the proposed ward or the disabled adult to attend a hearing, but not to say that could never happen. But I try to get the doctor on the PCME to say that the child should not attend the hearing. It is much smoother when your disabled adult who is incapacitated is not having to sit through an entire Zoom session and listening to their parents say words that they may not really understand, or they could get agitated, or could cause really a lot of anxiety. So I try to push for the disabled adult to not attend the hearing. Okay, once guardianship is granted, you get letters of guardianship. Again, your attorney should help you with doing all of that. Most courts will set a bond. It is a small bond, could be yearly. We're talking $50 to $100 maybe. But each year you do have to file a report. It is a pretty, standard, straightforward report that you can mail in. You don't necessarily need to hire an attorney to do that. It's just making sure that nothing has changed. You haven't moved. You haven't, nothing big in the ward's life has changed where the court needs to know about it. It is mandatory. You have to file that report. You could get fined, so make sure you do get that in. If you're clients of ours, we always send out a reminder to do that every year. Very close around the time you were awarded the letters of guardianship. If you move out of that county in Texas, you need to notify the court. Each county is different, so you just want to make sure that you're notifying them. Yes, there is modification of guardianship. Yes, there is termination of guardianship. So I know that guardianship seems so permanent and so I'm stripping away all rights for my child at 18. How can I do that? What if they get better? What if their, intellectual capacity, because of therapies and because of medication and is this really for no, it's not forever. That's why you do an annual report. I have literally listened to Harris County judges say, if we can grant rights back to your disabled adult, to your child, if you're the parent, we want to do that. We want to grant more rights to this, adult, they're an adult,
Yep.
so if at 18, that they cannot, for example, drive a car, vote in a public election, make decisions on marriage. But when they're 30, they're actually a lot, intellectually, they've grown, or again, due to treatment or medicine or therapy, they're able to now make those decisions, some, maybe not all. Then you can either terminate the guardianship or you can modify and include that right back. Okay, so I will touch on this because I know I want to get to questions. Public benefits. So I like to say that, the best clients that we love to help, they kind of need the trifecta. They need a guardianship, right when their child turns 18, because they do have severe intellectual disability, or they will be considered incapacitated at 18. They definitely need to qualify for SSI so they can get on Medicaid. And we now need a special needs trust, because if you are applying for SSI, you do have to stay up. And let me touch on that. Once your child turns 18, they are considered an adult. They're also considered their own household. Even if they live with you, they are their own household in the eyes of Social Security. Meaning, due to their disability, if they cannot work, and they cannot work enough to, care for themselves, they potentially will qualify for SSI. We help with those applications. If you're also going for guardianship and you're granted guardianship, that helps, right? SSI takes quite a while. It could take up to 2 years, which is frustrating because a lot of our clients get denied, especially if it's, autism is your diagnosis. Autism is a very, as everyone knows, it's a spectrum. And so courts want to get to the hearing stage. Social Security Administration does. And we help with that. Gidget Tyler is the attorney that helps with the Social Security applications. If your child, has worked for a few years and paid into the system, and then now, again, because certain agreements aren't working, now you're having to get guardianship, then she or he may qualify for SSDI. So that's definitely something to look into. The reason I say that, if you do qualify for SSI and you get on Medicaid, it is income based. So you do not want your child who is receiving public benefits to inherit from you. And that's also what we can help with our special needs trust. So I know that's a different topic, different webinar. I've done one of those too. So look at all those wonderful YouTube videos that Consolidated Planning Group posts. But yeah, I like to say that's kind of the trifecta that we like to help our clients with, is guardianship, getting that SSI application in. That is no upfront cost. We only get paid by Social Security if we do get your child on benefits, and Social Security pays our firm directly. So it's nothing that you have to pay out of pocket. And then estate planning, making sure once you're on public benefits that your child never gets kicked off because of some type of inheritance. So definitely get those wills and trusts updated.
Absolutely. This is such great advice, Carly. I love hearing from you. So I'm gonna hit you with these questions. Are you ready? Okay, we've got that one. So if an institution does not accept a power of attorney, are they liable for consequences of that? Like if you tell them, hey, my child can't, and they say, yes, he can, and then what?
Okay, are they liable for
If the
performing a medical procedure that they're unsure if they received consent? Is that what you're saying, or
if the institution does not accept the POA,
accept it?
are they
Okay.
liable for the consequences? If you tell them that the child is not competent and the POA is evidence, do they have to prove competence?
So I don't really, okay. Again, medical power of attorney. You have to prove that your child is disabled and incapacitated enough that now you have to consent on their behalf, right? So let's take an example of someone who does not have any disabilities, but has a medical power of attorney. So if I were under anesthesia, I cannot consent for a medical treatment that that maybe I need. So my husband's my medical power of attorney. He would have to make that decision for me because I'm under anesthesia. I cannot consent. So a doctor legally, and they will be liable if they don't, they have to get consent from the person that they're treating, right?
Right.
If they're only getting consent from the parents and they know that the child can consent, that is more the liability that doctors are worried about. Accepting
Right.
medical power, if they're not accepting a medical power of attorney, that would be shocking. And for example, if your child is, due to their disability, maybe they've had a seizure and they've passed out or whatever, and they can't speak, right? They cannot consent. Then yes, absolutely, you as a medical power of attorney have the right to make that medical decision. If the healthcare provider is not accepting it, that would be shocking, and yes, they would be liable.
Yeah, that's why it's important to plan ahead for these things and
Yes,
put it
plan
in
ahead.
place and be ready to go, right?
Yes.
This person says, my wife and I were granted co-guardians for our daughter, but she can't get paid to be a provider through class because now she's a guardian. So we didn't know that when we applied, and can we go back and change it so that she can get paid?
That's right. That was a question I saw that came through on the email to me. So I have not experienced, right, this exact case scenario. But if you can prove that in the best interest of the ward, that your child does not need co-guardianship and for, reasons that are specific to your family, I would absolutely petition the court for a modification of guardianship, if that's going to help your family the most. And you can prove to the judge that it is needed, right? I agree. I mean, if you being paid as a caregiver is the only way to go through, that specific program, by not being a guardian, and that will help your family the most, I would say try it. Can I promise that Medicaid will accept that? No. Will they, try to deny you anyway? Probably. Like, oh, you live in the same household, you are the guard, will they try to deny you? Probably. But go for it. I mean, try. I always say that. I'm always like,
Yeah.
go for it, try. If it helps your family, try, do whatever you can to get services, as many services and support as you need.
There you go. That answers most of the questions here.
Okay.
So this person already has co-guardianship of a minor. When he becomes 18, do you proceed as if nothing happened before and go on with this new guardianship, or what do you do?
Yes, in Texas, guardianship of a minor is through family court. Guardianship of an adult is through the probate court. So it is a completely different process. I also get that question a lot. What if I die? The guardian dies. Absolutely have a declaration of guardianship signed. You really need that. That's part of our estate planning documents as well. Declaration of guardian is so important. It's really good evidence in the court that shows who you want to be guardian if you're gone, right? That is very vital to have put into place. Is it automatic? No. You do have to go through the court process. You're not trying to prove guardianship anymore. You've already proved that, but it is the new guardian, the successor guardian that you're declaring should be guardian of your child. They have to make sure that they get the background check, right? That they are a good person, you know, a good guardian. So you
And
are going.
this last question
Yeah.
goes with what you're saying right now.
Yeah.
Can there be a previous felony record? Does it have to be like a certain age? Is it certain felon? What about a felony record?
I would say, can a parent have a previous felony record from over 30? Is that the one you're looking? Yes. I would say depends on the felony. Again, it's up to the court. So they're doing their own background check and the attorney ad litem. So there's two people, the judge and the attorney ad litem. It wouldn't be up to me, right? As your attorney, I would advocate for you, right? That is my job. So I would prove that that felony charge 30 years ago is not applicable to who you are as a person now. And we would touch on that at the hearing.
Okay. It's 1 o'clock, it's 1:01, actually. There's one more question. Do you want to take it?
Of course. Yeah, I have time.
Okay. You said that institutions can reject the power of attorney if the person is present, if the person disagrees with the power of attorney, which in that case, that's what the person was asking about the consequences. What if the person says, no, I don't consent, and then the family says yes, the person says no, and then there's consequences?
Yeah, I would say. And are they talking about health or financial?
I believe they're talking about health.
Yeah. Well, they said not just medical too. So
Yeah.
I would say financial institutions for sure. If there's any type of disagreement or they feel like there's any way that the principal is saying no or wanting to revoke it, they're gonna lock it up. They are not gonna want to be sued by anybody, right? So that's more frustrating. Health institution, honestly, they would have to do what's in the best. I would say they would have a duty to the person, you know, receiving that medical treatment or not wanting to receive that medical treatment. Again, it's those institutions. The reason why they're not accepting certain things or during certain situations is because they're concerned about being liable. They're concerned about being sued. It is frustrating that we do live in a litigious society, but that is the primary reason I see doctors and financial institutions not wanting to get involved. And then they just kind of say, okay, well then get a court order.
Yeah. Yep. All right. Thank you so much, Carly, for being here with us today. And everybody who has attended today, you will receive the slides and the link to this recording in your email later today. If you have further questions, you can certainly reach out to Carly. I put her slide up with her contact for a while, and this is the slide for contact info for Consolidated Planning Group. We would love to meet with you to do a free consultation. I hope everybody has a fantastic week and stay safe out there, okay, everybody?
Yes,
and again, thank you for being here with us.
Of course. Bye.
Thank you. Bye-bye.